Hello, you wonderful people of YouTube. So it's been a while since I posted a video, well, other than the earlier simplified of history video. Well, I'm here with another one, and I waited a couple of days to do this one because this is going to be a pretty interesting little video we got going on here today, and it's about Kyle Rittenhouse. That's one of them. The second one is about Andrew Coffey IV. So, why am I talking about these two cases, just in case you're not familiar? Well, both of them are self-defense cases. Kyle Rittenhouse received a lot of national attention for his case, as you couldn't go anywhere without seeing something about Kyle. The other, Andrew Coffey, back in 2017 or 2018, I believe it was. In 2017, in Indian River County, down in Florida, that's where Mr. Coffey's case took place. Now, both cases, someone died. Both cases, the people who were on trial acted in self-defense. Now, here we get some difference. Kyle Rittenhouse, because I know it's going to be brought up, was a 17-year-old white male in Wisconsin during the Black Lives Matter protests. Coffey, Mr. Coffey, I'm just going to call him Andrew, Mr. Andrew, he fired 10 shots at Indian River County Sheriff's Department deputies, and he claimed self-defense. Now, the way our society is today, most people will hear that and they'll be like, oh, well, I guess Kyle was found not guilty, as we all know, and Mr. Coffey was found guilty. That's the way the logic seems to be working, the way people think this logic works. But, hold on now. Now, again, both cases, a person passed away. In Kyle's case, Kyle was killed 2 attackers and then shooting 1 man in the arm in self-defense. Andrew Coffey, on the other hand, was woken up one morning by police barging through his door. Now, and he picked up his firearm, his pistol, and as he said, it goes, the defense said Coffey was sleeping and through the flashbang was gunfire, so he fired his gun because he thought he was under attack, and really he was. Mr. Coffey was a victim of no-knock warrants. So, I mean, I've said it in countless videos before, but I believe that red flag laws, no-knock warrants, no matter what they are more hazardous to everyone involved, whether it's a criminal or the police officer that are involved in these shootings. So, now we got that stage. So, now, I will say Mr. Coffey will still be going to prison due to his shooting, but he was found not guilty on all the other attacks, including murder, because the police shot his girlfriend and she died from 10. Unfortunately, she passed away from 10 gunshot wounds, and she actually passed away on scene during the gunfight. So let's go to Rittenhouse real quick. Let's unbox Rittenhouse's case, because there was a lot of stuff going on. One, everybody goes, well, why did the judge throw out the weapons charge? Well, in Wisconsin, it was actually legal for Kyle to be carrying that rifle. 16 and older, you are allowed to carry a rifle. Okay? Now, what the prosecution was trying to do was not reported at all until the day it got thrown out. What the prosecution was trying to do was use the weapons law that states under 18, a person cannot carry a pistol or SBR, which is a short barrel rifle, but I'm going to say SBR instead of dragging this on. So it was thrown out because Kyle was, one, legally able to have access and carry that firearm, and two, the prosecution did try to lie against Kyle. One is very obvious, as the M&P Sports 2 from Smith & Wesson that Kyle had that night was mostly a stock rifle. Well, if you watch the videos, the prosecution actually did change the stock on the rifle that Kyle was carrying. It went from the M&P's style of stock to a pistol brace, which federally is illegal by the ATF rules and regulations that all responsible gun owners have to go by. So the prosecution is actually lucky there that the ATF did not want to file any charges against them, because it would not have been a good day for him. And then two, the prosecutor in Kyle's case actually committed aggravated assault when he brandished his firearm towards the jury and those in attendance in the courtroom. Under no circumstance is it legal to point a firearm at someone unless you are under attack. So there was also some other modifications done. He tried to have the barrel shorten a little bit, and you can tell that from a picture of an actual M&P 15 and to the rifle that you see in the courtroom, which actually had the pistol brace on it. It was missing the A2 style front sight, which also acts as the gas block. It was shaved down slightly, and so that's what they were working with. That could there have been a mistrial in this case? Yes, there could have been a mistrial in Kyle's case due to the way the assistant district attorney was handling the case and everything that was going on there. Now, let's go to Florida in the Andrew Coffey case. The Andrew Coffey case, like I said, officers busted through his house with a no-knock warrant. He was being served that no-knock warrant for drugs. Mr. Coffey is a felon. That is why I said that he is still going to be facing jail time. Now, throughout the entire case that Andrew Coffey had, he admitted straight up that he was legally not allowed to own said firearm, and that he fully intends, and he did plead guilty before the trial even started. He did plead guilty to that weapons charge. Now, what they're trying to do is, for the time that he's already spent in jail and in prison, they're going to try to get the judge to turn that into basically suspended sentence for time served for the felony for illegal possession of a firearm by a convicted felon. So, one of the big questions you're going to hear a lot of people say is, well, why didn't Coffey get as much media attention as Kyle? Well, one, I'm going to tell you straight up right now, and yes, I am going to get political. One, Andrew Coffey was a young African-American male in the Deep South who used a firearm to defend himself, where Kyle was a 17-year-old white suburban male. So the Rittenhouse case carried more leverage to the picture overall that the media is trying to paint, where Andrew Coffey, on the other hand, whose case was actually a lot more important than what people really think it is. It goes beyond innocence and guilty in that. It also goes to, at what extent is the average American citizen allowed to defend themselves? And that's a big thing, because the fact that Andrew Coffey IV was able to fire at police officer, exchange gunfire from the no-knock warrant, because he felt that he was under attack. And then he also owned up to the fact that he illegally had that firearm. He knew it was illegal, but he still did it. Now, this is what I find interesting. In almost 99% of the states that have stand your ground or even castle doctrine. Those two rules of law cannot be invoked if you're in the middle of a commission of a crime when you do that. So let's say that I come up to you, I pull out my pistol to try to rob you, you pull out your gun, I shoot you. I cannot claim self-defense. Simply put it, because I have committed another crime. So there was a crime being committed with a felon having a firearm, and I actually applaud the jury and I applaud the judge down in Florida for saying, wait, let's ignore that, let's deal with that after this trial. Right now, let's deal with the self-defense part of the case, and I amend that immensely because it should have been. And with all that said, I do believe Breonna Taylor's boyfriend should be free, and the Andrew Coffey, the fourth case, is actually setting that precedent. At this point now, that sets the precedent where Breonna Taylor's boyfriend can get his charges dropped and his record sealed, because again, that was a no-knock warrant. The police busted through the door, and her boyfriend started firing his gun out of self-defense. And he was not a felon. He legally obtained that. He had a concealed carry's permit, which doesn't matter in your home to begin with. I'm just stating facts that he had and why he should be free at this point. So hopefully, I got some news coming up on that where I'm going to try to do something, try to unite us and do something on behalf of him. But so let's go back to Kyle. Kyle was chased, so he retreated. In some states with stand your ground, before you're able to invoke the use of lethal force, you have to exhaust all methods of escape to get away from said problem. Well, in Wisconsin, like in Georgia, Tennessee, and other states, Wisconsin does not have a duty to retreat clause in the stand your ground law or their castle doctrine. So there's no precedence for that whatsoever. So Kyle did not have to turn and run away from the men that were chasing him. Okay? Now, I'm not going to get into semantics in this video right now. Everything's been said already, but I will say this. There was a gun fired from a pistol that someone in the crowd fired behind Kyle while he was being chased by the first person who caught up with him. And Kyle continued to run to try to get behind the police. Now, earlier in the day, I don't remember if y'all know and play it back in your heads, go watch the video. The first attacker of Kyle's, earlier in that day, actually got into Kyle's face about 3 or 4 hours before that and was aggressive and threatening to kill Kyle. And that is on video that has been posted. So, Kyle, in his head, he's being approached by this guy that earlier in the day threatened to harm him. He turns around and starts running away. As he's running, behind him and behind Rosenbaum, there's a gunshot. So, of course, Kyle is going to freak out even more as he's being chased. And it's not just him. There's several people are chasing him at this point. Well, he trips over himself. He falls down. Rosenbaum reaches to actually try to grab the gun. There's no telling what he would have done with that gun. But that in itself is pointless at this point, as the number one item used in the United States for homicide is actually fist. That's the number one thing. Rifles, firearms in general are not even in the top 10. So, Kyle fired his 4 shots, 3 of which struck Rosenbaum, and another one actually struck a photographer for the Associated Press, who was a witness and even stated that Kyle was acting in self-defense, and he didn't want the charges pressed, but they were pressed anyway. So that was the unnamed person was that photographer, and he was actually shot in the leg. and he had no ill will towards it. He understood. Now, the second attacker who came up after Rosenbaum, or I'm sorry, I'm butchering that name and I apologize. The second attacker had a skateboard. Second most used item for homicide in the United States is blunt objects like hammers, screwdrivers. A skateboard would be considered that also. So Kyle has now been attacked by 2 people. And then the third person, who even in court admitted that Kyle wasn't even pointing his gun at him until he approached Kyle and pulled out his pistol, and then Kyle fired on him. Now, the last person, the one who had the gun, who had the pistol, who was shot in the bicep, is a convicted felon and was not allowed to own firearms. But think about this though. He's not facing any type of criminal charges for that. The DA gave him immunity from those charges to testify against Kyle. So keep that in mind. They're basically allowing a convicted felon to own a firearm just because they were trying to convict a 17-year-old young man who acted 100% within the legality of the system. Now let's go to Andrew Coffey. I've already summed a lot of that up. He's owning up to the fact that he made the mistake in having a firearm as a felon. So, what can we clear up right here? One, it's not a race issue on this one. As Kyle Rittenhouse, who was labeled a white supremacist by Joe Biden and other people on the left, he shot and killed 2 and injured 1 white man. Coffey attacked police officers. Well, I'm not going to say attacked. Coffey defended himself against police officers. And on the very same day, this past Friday, which was November the 19th, on November 19th, both of them were found not guilty with self-defense. So, I've seen the post, the very dramatic post of people saying, oh, well, this means it's going to be legal to go out and kill people. No, not at all. Both of these cases actually further cement the fact that us as American citizens, no matter what color, race, creed, sexual orientation, or anything else, has the inevitable right to defend themselves through the Second Amendment. And I've said it before, I'll say it again. During some of the classes I do teach for tactical firearm training, basic, advanced, whatnot, and I make sure I know the laws for every state, and thanks to USCCA, you can too by downloading their nice app, going to their website, signing up and getting into their chat rooms. On there, they have thousands of hours worth of training videos that you can take part in if you don't have the money, because I know things are tight right now. If you don't have the money to go out and go get the training yourself, they have videos that you can watch who are taught by some very well trained and well knowledgeable individuals in firearms. But like I say, in the classes that I teach for firearm, I set aside 3 to 4 a year where it can be for discounts to women, discounts to minorities. So just because I feel that everyone has the right to defend themselves and they should do it right. Learn how to control your firearm, learn how to grip your firearm, learn how to reload your firearm, learn the in and outs of your firearm. And unfortunately, with both cases, 4 people lost their lives at an early age, or mid-age, I would say. I, for one, have been involved in a self-defense shooting myself. I know how stressful it could be and be in that moment. Luckily, talking about training some more, my training allowed me to be able to place my shot in a non-vital area that I knew had a good chance at stopping the attack without having to escalate completely to the night sleep, to the forever sleep that could have happened. And in my case, for instance, I actually went and actually asked for leniency for the guy who attacked me. He suffered from mental health issues. He's also a drug addict, and I feel that he would have been better suited going into a treatment program, getting the help that he needed, getting on the medications and stuff that he needed, than being sent to a prison camp in Georgia. And so, yes, I was the victim, but I still showed compassion. And I do still show compassion. I can guarantee you that Kyle himself had a lot of compassion. And I mean, the whole reason he was there was to try to help protect his community, his father and grandparents. He had family there in Kenosha. He only lived 20 to 30 minutes away from Kenosha, where he lived with his mom in Illinois. So, and then the big thing with the Rittenhouse thing is, well, he shouldn't have been there. Well, technically, no one should have been there. After 5 p.m., there was a curfew for the entire city of Kenosha, Wisconsin. So none of them should have been there. And then, out of the 3 people that he shot, the closest one lived 45 minutes away. So they were not people who lived in that neighborhood, who lived in that community. So by trying to make the argument, you're creating a fallacy, a fallacy within itself. Now, I will say that a 17-year-old should have not been in a situation like that where he took it upon himself to enter a violent situation. I do agree with that. But however, I admire what Kyle did, because Kyle carried a medical kit because he was there to try to help people. Even the people he was trying to help, even the people that were trying to set fires and destroy Kenosha, Wisconsin. He was there to help them. It didn't matter who you were, what you were, why you were there. Kyle tried to help anyone. He cleaned up graffiti because he had pride in his community. And he was literally unfairly labeled. Andrew Coffey, on the other hand, had no media coverage outside of the local area in Florida where this took place at. And simply because I 100% believe and truly believe that it would have ruined the media's calling point about self-defense. And I want to link an article in the description where you can go and read about Andrew Coffey, the Force case yourself. Because everyone knows Kyle, so I'm not going to leave any article on that, because everybody's heard it unless you've been living under a rock. But for Andrew Coffey, I am going to post a link to an article down in the description below, or in the comments, the top pin comment, one of those, where you can go and read that for yourself. I believe the outcome in court for both cases were good. Were great, were wonderful. I love the fact both of them were found not guilty. I will say that one thing is, Kyle shouldn't have went to court because it was clear-cut self-defense. And honestly, I don't think Coffey should have. But logically speaking, just the fact that he fired on police officers, you could kind of figure that one would have went to court regardless. Even if it was roles reversed, Kyle Rittenhouse did what Coffey did, and Coffey did what Kyle did. I still think that it would have gone to court. And it should have. That one is one of those where you need to go to court, try to unpack everything, what body cam footage and stuff like that was there. But in the end, there's still a lot of work that has to be done for fair and equal gun rights in the United States, and these two cases prove that. Where if it wasn't for these two cases, if it wasn't for a firearm in either one of those cases, Kyle might not be here. Coffee definitely wouldn't have been here anymore. Unfortunately, his girlfriend was killed by police, and this is why we need to do a reform to the no-knock warrant, red flag laws, stuff like that. Are you going to keep having cases like the Breonna Taylors, Dylan Lump? If you don't know who Dylan Lump was, he was killed by police officers while he was asleep, who were there to serve a red flag warrant on him, which is another version of a no-knock warrant. But instead of even trying to come through the door, police actually opened fire on outside the home, killing Lump, who was a young white male. His girlfriend was wounded, and in the end, they actually found no firearms whatsoever in Lump's case. But the officers involved didn't face any charges, and lawsuits are placed against everyone involved in that were actually thrown out by a judge. So, well, that's going to be my video for today. Please have some discussions in below. Click on my social media profiles and stuff. They'll be linked in the bottom. Give me a follow. We started a new Facebook page, and there's a new Twitter page. The very first episode of Pew Nation podcast will be coming up soon. So go to Apple iTunes, type in Pew Pew Nation, where we'll start having some wonderful discussions like this, and we keep it rocking and rolling. I love all you guys. I hope y'all have a wonderful and happy Thanksgiving. Y'all all be safe. No drinking and driving.